Indian news ma kwaba assign the ba one kasa fidie so bio. Na maka trust before anything else na just a share na ebiem so kwa na wo subscribe to your channel no. What's the fa political news there? Never governance. We catch you sa pan input of ma yet. Na pan to forma yet there. Ane na nsɛm foforɔ bi nso asan asi. Benim sɛ wo de nsɛm a de ba nyina na ya na ya wote na ya wohɔ na ya wofɛ nso so. Nti no nsɛm foforɔ bi asi a Indian news yan so pan ye to for me baby ati nyina chi no ye nsa atumi aka bi na yaso nso atimi ate saa nsɛm bi. Yentie nsɛm member sisi a na mpanifo mpo se kakum no ye chi no koku enum. De ba before that no subscribe to your channel no. Sabeka all other news fa politics one de opesa wote no ɛho. Itie ba ebe ba bia susu anso person de body no fa na de asie bia no so fa comment anso to ase na yenkenkan informaw de ready na emeko yentie nsɛm mercy a utie no fa comment to ase ba de emfa nchemu no so ento aso yentie mra.
How to schedule or conduct its business and debates. Now, see, consequently, this court, generally conscious of the doctrine of separation of powers, has been consistent in the recognition of its mandate under Article 2958 of the Constitution to inquire into whether any branch or authority in exercising its function or role is doing so in accordance with the Constitution. This is because, notwithstanding the express reflection of the doctrine of separation of powers, Article 2958 provides that no provision of the Constitution or of any other law to the effect that the person or authority shall not be subject to the direction or control of any other person or authority in the performance of any function under this Constitution or that law shall preclude a court from exercising jurisdiction in relation to any question whether that person or authority has performed these functions in accordance with the Constitution or the law. It is an elementary principle of constitutional law that the judiciary, particularly the Supreme Court, stands as a sentinel of constitutional fidelity, vested with an extraordinary mandate under Articles 2:1 and 131 of the 1992 Constitution to scrutinize and review the actions of its coordinate arms of government, the executive and legislature, ensuring that their deeds align with the venerable dictates of our Constitution. This solemn duty, in my considered opinion, places the judiciary at the heart of democratic order and safeguards the sanctity of constitutionalism. To church and in akambra akadiobekenina no we no kan eye na nije say at the end of the day executive nya asem, legislature nya asem, no obi anya asem a ye de ba beto eye court, Supreme Court nim say ye church nsem nimu na eno no ma ne hu ne say ye ka democracy na eye Supreme Court no ana the judiciary no na eye the heart omo no mo ye democracy na den akoma. Also, similarly, I am of the opinion that this court must always be conscious that while the Constitution entrusts it with the authority to review, sufficient restraint and caution, sufficient restraint and caution must always be applied so as not to upset the delicate balance that exists between the three coordinate and co-equal arms of government. Therefore, in the discharge of our judicial mandate, the relationship of our three arms are being separate but interdependent must eternally nuance our judicial posturing to ensure that in our attempt to achieve constitutional adherence, we do not, in so doing, render either of the two arms inoperative, inefficacious, or ineffective, and thereby needlessly frustrate or obstruct the due exercise of their powers, functions, and respective constitutional prerogative. Into utie points 33 na asem a work can say ono no de bia no aye na adwentre se omo judges no omo di asem a wo mfa omo adwen ento ho ehu ne say yes se executive nya asem omo ba ye ho, legislature nya asem omo ba ye ho de, but mayemma enye yetrimu ndada yen se enu hu nti yedi omo so eno hunti ebetumi atro mo se ne omunyi omu adwuma. Because basically, you see, he's speaking about this whole Article 146, which shows once Emra MPP for share adwuma na asem omo share asem so omo dey court no. Asem wakwa meka and say it looks like these people no, what they want is that the president, the constitutionally mandated duty yediama president, because Article 146 it's a constitutionally mandated order yediama president no. As MPP for person president ni be na adwuma. Into tie nsemo a Justice Yoni Kulendi welcome upon 34 na. Osi ono de bia ye na dwentre. Se wo bia ba ye ho ema ye trɛtrɛ emra ni mu trɛ omu nti. Ma enyenyen se ye betumi edi omo so atrɛ omo se ne omu nyi omu adwuma. Basically no, point 34 no. That is what Justice Kulendi Orka. 35. Or say under constitutional law, there is a strong presumption of constitutionality or regularity in favor of official acts of the executive and legislature. Courts generally begin with the assumption that public bodies or officials discharge their constitutional duties lawfully and in good faith. This presumption of regularity is a difference doctrine that places the burden on a challenger to show otherwise. It means that judges do not lightly second-guess the stated reasons or actions by public bodies or officials and will credit them with constitutional compliance unless clear evidence proves a violation. Also, under Embra, constitutional law, under Embrano, there is answer na case bi kra beba no. Ye ka se bibi a presumption and atre say adwentre bi wo ho, adwen bi a ewo ho deda, adwen bi wo ho deda da say the executive, which is the presidency and the parliament no. Adwen wo ho deda da. Se adie bi a wo mo ye bia no, omo de mbra na eye omo adwuma. Inti court bi a wo betena sa nkrofo no a case, se executive for case eba judges enim ana legislature case eba judges enim a. Court bi a wo betena asem ne so no, they begin with that assumption. Say the public bodies no, officially no, they are discharging their constitutional duties lawfully and in good faith. Inti President Niko Koye Bibi near the neighbor court. Initially, no, the mindset at court no ebenyane say, oh, president no, ayembra ne man to me say 1 year say juma no, and a warrior. Say parliament eko Koye Bibi na obi at the back court. Judges no initially in the position they initially begin with, and they say, adia parliament no eye no, embra ne mo mutumi. Inti wa wo de asem ne ba no, e wo say wo and a wo prove judges no more who say dabi president na dia warrior no embrana money to me. It's just like President His Excellency John Dramani Mahama, the removal of the Chief Justice ni say. Inti judges ni there initially no mutrimu no adia His Excellency John Dramani Mahama warrior no embrana mane kwan so we to me Chief Justice no e was so the processes be so and away these are processes so odi Chief Justice no. Inti sende asefwa go Freda mi di wenim se mo ba court. You need to get evidence bia ebetre yebe hu ne se dabi ejuma His Excellency John Dramani Mahama warrior in the removal of the Chief Justice no emra man ne sa kwan ne kra e wo se mo ba betre se emra man ne sa kwan no, but clearly they weren't able to prove that in court. Also, in the specific case of the executive, the rationale for this presumption is twofold. First, it acknowledges the constitutional role of the president as an elected official entrusted with significant responsibilities. A trust that should not be casually called into question by the judiciary. It was in fact about president in the krana yatone swaba and a Ghana for the 2 million in sem. Inti Ghana for the GD action in sem. Inti sa GD na Ghana for the action in sem no. Sebe untumi mfrene sa kemba court. Say president akwa ye bibi nti no ye de neighbor court say judges no entwe president na so and a president na dia wo ye no ye mbongu ye nya ne sa because ono no ye elected o omo judges na wo moti wo no Ghana for nto so omo so aba nti president ono ye elected no na trese tumi a ye de ahye ne nsem no eso. Also second, it serves practical institutional needs. If courts had to scrutinize every executive action without this presumption, they would become entangled in constant oversight of the executive. Into the second one, the reason why the president here bibia na wo mo judges no edikan ehwomutrim say president no or the to me and yes ade ne say so mo kokoyo mo adwen say oh president asem aba na oni to me a wo de yes ade na omo ahwe ne ye ya omo judiciary no ebe tre executive ne say ne omo nyi omo adwuma, which will be against the constitution. Separation of powers, no, it will be against that. You see how Justice Kulendi watch mu ama say wonye lawyer krana obeti ase that the thinking into the ruling and all that. Ati see, which would undermine the separation of powers and paralyze the executive branch. In my view, this could not have been the intendment of the framers of our constitution in investing the courts with our mandates under Articles 2:1 and 131. So see what no there, ohun say omo moye constitution no. Omo anye say judiciary no embetre president no say nya wonye na edwuma. And there's a president no or ye na edwuma no yi chief justice free ho a omo judges no omo ntumi ntre president no say nya wonye na edwuma. Omo moye constitution no omo anye ne saa. The presumption is captured under Section 37(1), our Evidence Act 1975, NRCD 323 as follows. It is presumed that an official duty has been regularly performed. See also in the case of Ghana Ports and Harbours Authority and Captain Ziem versus Nova Complex 2007 to 2008, 2 SCGLR 806 at 808. In his essay entitled Federalist, number 78, titled The Judicial Department, Alexander Hamilton noted that the judiciary has no influence over either the sword or the purse, neither force nor will, but merely judgments, highlighting that the courts cannot govern or execute policy, as that is the realm of the executive and legislature. See, the framers of our constitution, obviously influenced by both British and American constitutional traditions, created a system where each arm of government is meant to be a watchdog over the others, but not a usurper. Omo moye constitution no, embra na omo ye no, omo hwe America for any Britain for a constitution. Na omo ya constitution no, omo ka say arm of government bia no en check the other person. Nanso yanka se obi mbra mbedi obi so. Yaka se obi mbedi obi so eno na ye friend say usurper. So say we hear Ghana constitution now. Yes, the judiciary no, you can check the executive, you can check the legislature and all that. The executive can also check so and so, but yanka se obi mbedi obi so. Consequently, in a constitutional democracy such as ours, the separation of powers implies that each branch should largely be free to operate within its own sphere without undue interference from the others insofar as they remain within their constitutional remits and assets as warranted by lawful and prudent checks. In the judgment of the court dated 13th April 2022, in suit number J111-2022, titled Michael Ankoma Nimfa and James Jachi Kwesin, this court affirmed its jurisdiction to entertain application for interlocutory injunction relief in matters such as the instant case, invoking its original jurisdiction under Articles 2:1 and 131 of the 1992 Constitution. We held in that case that it is beyond dispute that this court has jurisdiction to entertain injunction applications whenever its original jurisdiction is invoked. This position is consistent with a long-standing judicial tradition. In an earlier case of Republic versus High Court, Kofoedua ex parte, Ansa Otu, 2009, SCGLR 141, Enim Yeboah JSC, as he then was, noted. The jurisdiction to grant the interlocutory injunction is exercisable by both the Superior Court of Judicature and the lower courts in Ghana. It is a relief with the common law courts. It is a relief which the common law courts have always granted in the exercise of their discretion. When the circumstances appear to be just and convenient, it is however granted to protect rights and in some cases prevent any injury or damage in accordance with laid down legal principles which have developed as a result of case law over the years. In a milestone case of Welford Kweku versus the Attorney General and the Electoral Commission 2012, GHASC 38, Prof. Dateba JSC articulated the well-settled principles for granting interlocutory injunction as follows. The requirements are, first, that the applicant must establish that there is a serious question to be tried. Second, that he or she would suffer irreparable damage, which cannot be remedied by the award of damages, unless the interlocutory injunction is granted. And finally, that the balance of convenience is in favor of